A group of students just changed the world. By now, you must have seen the headlines that countries can now be legally held responsible for failing to act on climate change. What this means is if a country drags its feet on climate action, it can now be considered a breach of international law. But here is what most people haven't heard. The groundbreaking ruling didn't start in a courtroom. It started in 2019 when a group of students from Vanuatu, part of the Pacific Island Students Fighting Climate Change, began lobbying their government to take bold legal steps. It gets interesting. Their call was to ask the International Court of Justice for an opinion on whether countries have legal obligations to act on climate change. With support from the World's Youth for Climate Justice campaign, their push reached the UN General Assembly, which in March 2023 formally requested an advisory opinion from the ICJ. Following public hearings in December 2024, the ICJ delivered its response just days ago on July 23, 2025. The court confirmed that countries can be held legally responsible under international law for failing to prevent climate harm and for violating the rights of present and future generations. But here is an important detail: the ruling is not legally binding. The ICJ gives two types of rulings: contentious cases, which are legally binding decisions between countries, and advisory opinions, which are responses to legal questions from UN bodies or agencies. These are influential but not enforceable. This was an advisory opinion, meaning countries can't be forced to comply, but it still carries massive legal, moral, and political weight. It's already expected to influence national courts, boost ongoing climate lawsuits, and strengthen the case for stronger climate action and finance. And all of this because a group of students wouldn't take no for an answer. Change often begins in small places, and we must never forget that.